Welcome to the Codecast podcast. Real-world insights for your daily medical coding and billing processes. And now, here's your host, Terry Fletcher.
Hello, everyone, and welcome to the Codecast podcast today. My name is Terry Fletcher. So it is a beautiful day here in Hawaii. So I'm actually on the island of Oahu, and we are staying at the Four Seasons. So I'm actually coming live there. I usually don't do these live, so it's kind of interesting to do that. But I don't know. I just wanted to say I'm podcasting from Hawaii. So it's a beautiful day here, October 15th. 2024. So first, I did want to send just our hearts out to everyone who was affected by Hurricane Helene in North Carolina, South Carolina, Florida, and Georgia. And I really hope the rebuild is going well. You know, shout out to all the first responders. I know I gave and donated to SamaritanPurse.org, who were there with all kinds of supplies and medical supplies and water and insulin and everything that's needed for a lot of those victims. And I'm just so heartsick for them. And they also helped rescue puppies and you know, all kinds of pets. So, you know, if you can donate to a cause, that would be probably one to do that, because I'm not really sure how far the government's going to be able to help there with all the foreign money going out. Okay, so what are we talking about today? Well, we're going to talk a little bit about HIPAA, because there have been some news reports regarding things that are happening and not a good thing. So, for example, the New York Post and the New York Times posted that at least 12 Department of Veteran Affairs employees have been accused of improperly peeking, basically looking at and reading, at Vice Presidential J.D. Vance's and Tim Walz's medical records in July and August. So roughly a dozen or more employees had looked at the sensitive medical files, and they were not there for no other reason than they just wanted to see. And it has sparked an internal investigation, criminal investigation, into whether they violated federal health privacy laws, aka HIPAA. And I'll quote from the VA press secretary, Terrence Hayes. He told the Post that we reported to law enforcement allegations that VA personnel may have improperly accessed veteran records, and we take the privacy of veterans very seriously, and we have strict policies in place to protect their records. And to basically look at medical records when you are not treating that patient, they're not for your use. It's just because the patient happens to, or the former patient, or the medical records of, you know, this is VA. So these are military personnel, you know, both Walz and Vance both served in the military. Vance in the U.S. Marine Corps, and Walz spent some time in the National Guard. And that you cannot look at records unless it is about your practice, your providers, your immediate needs for that patient. Otherwise, that can be a violation. And authorities uncovered they call it the infringement last month during a routine review of the department's high-profile accounts, just to make sure that, you know, breaches don't happen. And when they asked they call them now the perpetrators, they asked them if they shared any of this data for those medical records with outside groups. Just even mentioning it will be a problem. They said that no, they were just curious to learn about the health status of the two VP contenders. Then you ask them. If you really want to know, go to a rally, you ask them. You do not go through their records and violate privacy. You know, that you can't access disability compensation records. That's actually kept more secure. But just to look at somebody's medical records for politics is absolutely a violation. And veterans trust the government and the VA hospital to, you know, protect their privacy and protect the confidentiality of their information. And the HIPAA, the Health Insurance Portability and Accountability Act of 1996, HIPAA, makes it illegal to get unauthorized access to an individual's personal health data. And violations of HIPAA can result into 1 year. It actually says up to a year behind bars, and penalties up to $50,000, not just dollars, not just for the VA's medical system or hospital where it was, or the Department of Veteran Affairs, but also to the person that made the violation. So this is not okay. You cannot do this. And then there was an article that I found in Decision Health's Part B News, and it talks about, there's another news story out of North Carolina that raised the question from patients, can they keep specific practice staff from seeing their records? I hate to say that, the medical community is a small community, because it's a vast community. But for example, I'm in my 40th year of healthcare administration. I mean, at one time, I know a lot of you know I used to be an RN. That was years ago. I haven't been a practicing RN for at least 20 years. But between that and being a coder for over 30 years, and a biller, an administrator, and then now really heavily on compliance education, I'm eventually going to come across somebody I know, or somebody that is familiar. And when that red flag comes up, I need to make sure that I, allude to that and not to look at that record. And so there was a situation in North Carolina, again, just back to the story. It said that in Charlotte, North Carolina, it was reported in May that a woman in that city got treatment for a very sensitive issue at a local doctor's office, only to find out later that someone against whom she had obtained a cease and desist order was working in the same office. This is a problem. She approached practice management several times to try to keep that individual from having any access to her records, but later learned that person had in fact accessed them without a legitimate reason. And the patient said, look, I don't want access to my records by somebody who I have a personal antagonistical relationship with. And, the question comes off, can a patient request access to their protected health information, their PHI, be off limits to a specific member of a medical practice that's handling the care? So according to an attorney out of Los Angeles, the short answer is yes. Okay. And you should if you're that kind of practice, make sure you take care to pursue the matter and document that. This attorney also says that these cases, can be considered insider threats, and the majority of them involve an employee accessing patient information that they had no business viewing. And in one case, which he said he was familiar, a healthcare employee accessed patient information for their boyfriend's ex-girlfriend and then shared that information with their partners so that they can use it to gain custody of their children. You can't do that. And if anybody wants to reference this Part B News article, it is September 23rd, 2024, Volume 38, Issue 37, Page 4. And that's why I love Part B News, because it has, and I always verify everything that's on there. It's got some really good, information here. And that's a problem. So HIPAA privacy laws definitely allows a patient's treating provider to access their PHI, but for other members of the care team within the practice, these records are only to be accessed on an as-needed basis, or what they call, and this is in the HIPAA rules, and I'm air quoting, minimally necessary basis. When a patient requests a restriction, legally the practice has to act. So now it may not be, depending on your state, if it's a complete slam dunk that this is what you have to do. I know New Jersey has some information there where they said the practice may find that preventing the staffer's access could be considered detrimental to the care of the patient. Also, there's employment law now. They were talking to a partner in a law group in New Jersey, said if by blocking access you're preventing the person from performing his or her job, but then you need to tell the patient if it's something that in those implications or issues, then that analysis means that you need to tell the patient, and then they can either find another medical provider, or you can deal with that employee. But there's federal and state implications. So, if, let's say, biller Jane Doe is the only biller in a medical practice, and without that biller having access to a medical record in that practice, they can't bill your insurance company for the visit, then there's going to be some problems on several different levels. But the problem is that the patient, if they have a good reason, especially a reason that they know there's sensitive information. We had a rule that came out, oh my gosh, like I said, I've been in this a long time. There was, when AIDS was first a really big deal in the 80s, there were two different, we didn't have something called HIPAA back then because it was the 80s, but we did have privacy laws. and AIDS information had to be kept in a locked, separate area, and then there was regular health information, is what they called it. That was, more accessible, but still had to be kept private. So nowadays, since 1996, there's all kinds of nuances when it comes to information, including mental health information, etc. And so there are a lot of factors into a decision of making sure that the right people and certain people can have or have not access to those medical records. And if you want to refuse to not allow those, say that the employee, you say, the employee has to have it, I'm not going to make those guidelines. You must have a really good, well-documented reason, because HIPAA will not be on your side. So if you agree to block that certain employee from seeing those records, then just make sure you're not violating the employee's right, and take reasonable measures to implement the restriction based on the patient's privacy, because that's actually what supersedes any employee situation. But confidentiality is such a big deal in medical records. And also, the other big thing here is this confidentiality cannot be shared with and disclosed with other employees or parties, or any workplace gossip that could happen, and there can't be any kind of potential claims of workplace harassment or discrimination. It has to absolutely be kept under wraps, including the patient's request, the assessment of the feasibility on who's allowed to see it, and how the restriction was implemented. But this is such a sensitive topic right now, not just because it's an election year, which I hate it when these things come up when it has to do with politics, but it has to do with you getting $100,000, penalties if you violate these policies, and also the protection of the patient. I just really have a hard time with people thinking that they can have major access to everything when you cannot. And that just, I can't tell you how much that really bothers me. And so make sure that you have revisited these policies. I'm sure many of you have, HIPAA compliance plans and programs. Well, add this one to it, that if you recognize anybody that, you're looking at a medical record that probably isn't appropriate for you to see, or if you find out and you hear that one of your friends is here and there and you don't need to see their record, make sure you avoid it, but let, the administration know so they can write it up. And please do not start looking for records or trying to access records that do not concern you and that could be, used against somebody outside of the practice. Also, make sure you're talking to, there's something that came up recently, make sure you're talking to your virtual staff too. When they are discussing insurance or claims or anything on the phone in their homes or wherever they're working virtually, and they have Alexa, Amazon, or they've got their phone that's on and they've got Siri, and or an iWatch even, that you yell loud enough and it'll pick up your voice. That's collecting data. And all of a sudden, for those of you on Facebook, I'm not, we'll get a notification saying, hey, you may know this person, but so does the patient, because they're collecting data. And so if your office is using any kind of cash app like Venmo, and you don't use the privacy on that, then that patient's going to get all kinds of, advertisements for things. And those cash apps aren't HIPAA entities, but privacy is such a big issue. I mean, I could keep talking about HIPAA forever until you guys are probably sick of me, but it's really a problem. So please make sure that you're good about that. You don't do that, that you are fine-tuning and always updating your HIPAA policies and plans, and make sure you're Googling the current HIPAA compliance, because this has been a really big issue in the news lately, and I just don't want you to get in trouble, and find out somebody actually did something you weren't supposed to. The Codecast podcast is brought to you today by Just Coding. Just Coding is your online continuing education destination. Pay one price and earn dozens of AAPC, ACDIS, and AHIMA credits annually. Save 10% off a new prescription. See what I did there? Save 10% off a new subscription using the coupon code SAVE10. visit justcoding.com to subscribe. Sometimes we're on autopilot, so hopefully that was helpful. Well, I am getting ready to go down now to the pool and have myself some coffee and enjoy my ocean view. I definitely needed a break this week, but it was really nice coming on doing the podcast with a view with the ocean in the background. And I hope everyone makes it a great day. And thank you for listening to the Codecast podcast.
For more information on medical coding, billing, auditing, and compliance, including how to hire Terry, follow Terry on Twitter at TerryCoder1 or visit her website at www.terryfletcher.net. Podcast producer Joe Kuzma. Music producer Dassassin Music.